Imagine this. Your wife is 8 months pregnant. She is in labor. You rush her straight to the emergency room. You are sitting in that waiting room absolutely terrified, gripping her hand tightly. Surprised, then 2 men in civilian clothing walk through the door. They are not doctors. They are not nurses. They are ICE agents. And they are scanning the entire room. Now, if you are like most people who follow this channel, you believe one of two things. Either you think there is absolutely no way because hospitals are protected zones and they cannot arrest anyone there. Or you think hospitals are now a danger zone and you are never setting foot in one again. Size, both of those beliefs are completely wrong. And either one has the power to permanently destroy your life. Pay very close attention to what comes next. Here at US Visa and Green Card Info, we do not deal in rumors. We do not deal in social media panic. And we do not deal in unqualified advice. We deal in law. We deal in official documents. And we deal in the truth. Today we are going to show you the exact federal directive that changed the rules around hospitals and immigration enforcement. We are going to walk you through 5 specific traps that are getting people detained right now in 2026 inside hospital facilities across this country. And then we are going to hand you a legal shield. The exact words you need to say if ICE ever approaches you or someone you love inside a medical facility. Do not skip ahead. Trap number 4 is the one that catches even green card holders completely off guard. Let us get right into it. Before anyone in the comments says this is fear-mongering, let us look at the official evidence together. This is ICE.gov, the official website of U.S. Immigration and Customs Enforcement. Not a blog, not a forum thread, not something someone forwarded in a group chat. On January 20th, 2025, the Department of Homeland Security issued a formal directive titled Enforcement Actions in or near protected areas. What did that directive actually do? It rescinded, it canceled, and it permanently removed the prior administration's policy from October 2021 that had formally designated hospitals, schools, and churches as protected locations where immigration enforcement should not take place. Then on January 31st, 2025, ICE followed up with its own internal memo titled Common Sense Enforcement Actions in or near protected areas, which granted individual ICE field supervisors direct authority to make case-by-case decisions on whether to conduct enforcement operations inside hospital facilities. Let us say that one more time so it is completely and absolutely clear. There is no federal policy in 2026 that automatically and categorically prevents ICE from walking into a hospital and making an arrest. That is not our personal interpretation. That information is published directly on their own official government website, updated as of February 20th, 2026. Now, does that mean you have zero rights inside a hospital? Absolutely not. The United States Constitution was not rescinded, and that is exactly what we are breaking down for you right now. Trap number 1 is believing the old rules still apply and still protect you. Here is something we hear constantly from people reaching out to us. Someone told them that ICE is prohibited from entering a hospital because it qualifies as a sensitive location. That was true at one point in time. Between 2011 and January 20th, 2025, the Department of Homeland Security maintained a formal standing policy that designated hospitals, schools, and churches as sensitive locations where immigration enforcement activity was expected to be avoided. The previous administration significantly expanded and strengthened that protection in 2021. That policy no longer exists in any form. It was formally rescinded on the very first day of the current administration. Now, a federal court injunction issued in March 2025 did restore some limited protections, but only for approximately 1,400 specific houses of worship located across 36 states. That injunction does not cover a single hospital anywhere in the entire United States. So if you are walking into a hospital right now believing that some automatic legal protection surrounds you simply because of the physical location you are standing in, it does not. And that dangerously false sense of security is trap number 1. Trap number 2 is speaking when you should be completely and entirely silent. This is the trap that is most heartbreaking because it is entirely and easily preventable. A survey published in January 2026 found that 48% of likely undocumented adults had deliberately avoided seeking medical care since January 2025 specifically because of immigration enforcement fears. But here is the deeply painful irony of that situation. The ones who do go to the hospital often make the single worst mistake possible once they arrive inside those doors. They talk to ICE agents. ICE agents are legally permitted to enter the public areas of a hospital, including the lobby, the waiting room, and the parking lot without any warrant whatsoever. And if they are present in those public areas, they are allowed to ask you questions. But here is what is absolutely critical for you to understand. You are not legally required to answer any of those questions under any circumstances. The Fifth Amendment of the United States Constitution grants every single person physically present in this country, whether they are a citizen, a green card holder, a visa holder, or undocumented, the absolute and unconditional right to remain completely silent. That is the one sentence that matters. If an ICE agent approaches you inside a hospital lobby or waiting area, these are the only words that should leave your mouth. I am exercising my right to remain silent. I do not consent to a search. I want to speak to a lawyer. Because the moment you begin talking, you may confirm your full name, your country of origin, exactly how long you have been present in the United States, and that information alone can give ICE agents the probable cause they need to arrest you, detain you, and formally begin removal proceedings against you. Your own voluntarily spoken words become the primary evidence used against you. Silence is not suspicious. Silence is a constitutionally protected right that belongs to you. Trap number 3 is running from ICE agents inside a hospital. This needs to be stated clearly and directly because it happens far more often than most people realize. Someone spots agents moving through a hospital hallway. Panic immediately takes over, and they run. Please do not run under any circumstances. According to established legal guidance from immigration rights organizations, physically running from ICE agents can legally establish probable cause for an immediate arrest on the spot, even if those agents had absolutely no legitimate reason to approach or question you before that moment. By running, you have unintentionally and instantly provided them with one. Running can also result in serious additional criminal charges, including obstruction of justice and resisting arrest. And once criminal charges are introduced into your immigration situation, your entire case becomes exponentially more complicated and significantly harder to successfully fight and resolve in your favor. Stay completely calm. Stay exactly where you are. Say the exact sentence we just shared with you, and then wait quietly for qualified legal help to arrive. Trap number 4 is failing to understand the critical and life-changing legal difference between two very different pieces of paper that ICE agents routinely carry. This is the trap that catches even lawful permanent residents and current visa holders completely and entirely off guard, because most people have never been taught this distinction exists. ICE agents carry two very different types of official documentation, and most ordinary people genuinely cannot tell them apart just by looking at them. But the legal difference between those two documents is absolutely everything in terms of what ICE agents can and cannot do inside a hospital facility. A judicial warrant is a document that has been signed by an actual federal judge. It will display the words United States District Court prominently and clearly at the top of the document. This type of warrant does legally authorize ICE agents to enter private and restricted areas of a hospital, including patient rooms, examination rooms, surgical areas, and staff offices. An administrative warrant, which appears as either Form I-200 or Form I-205, is a document signed by an ICE officer or supervisor rather than any federal judge. Leading constitutional law experts and major civil liberties organizations, including the ACLU and the Brennan Center for Justice, have consistently maintained that this type of administrative warrant does not satisfy the requirements of the Fourth Amendment of the United States Constitution to authorize entry into private spaces without voluntary consent. We want to be completely transparent with you on this specific point. This legal question is currently being actively challenged and litigated in federal courts. The government's official position is that administrative warrants may be legally sufficient in certain specific contexts. However, the clear and consistent legal position from organizations including the ACLU, the National Immigration Law Center, and the Immigrant Legal Resource Center is that an ICE administrative warrant alone does not authorize entry into a private patient area of a hospital without proper consent. So if you work at a hospital and you are watching this today, You need to know that you have the legal standing to ask any ICE agent presenting a warrant this specific question. Is this a judicial warrant that has been signed by a federal judge? And if the honest answer to that question is no, you are not legally required to open that door or grant access to any private patient areas. Trap number 5 is signing official documents that you do not fully understand. In January 2026, a 31-year-old construction business owner from St. Paul, Minnesota, was arrested by ICE during an enforcement sweep operation. He was subsequently transported to a county medical center suffering from 8 separate skull fractures and life-threatening traumatic brain hemorrhages. ICE agents then stationed themselves directly at his hospital bedside for multiple days following his admission. They attempted to place him in physical restraints while he was so severely disoriented from his traumatic brain injuries that he could not accurately identify what year it currently was. Hospital nursing staff actively pushed back against this treatment. Hospital administrators and legal counsel became directly involved in the situation, and ultimately a federal judge formally ordered his release from ICE custody. But now think very carefully about this scenario. What if he had signed a voluntary departure form while in that severely disoriented medical condition? What if he had unknowingly and permanently signed away his legal right to appear and present his case before an immigration judge? Because that is precisely what those forms legally accomplish once they carry your signature. And once a voluntary departure form has been signed and formally processed, it can trigger a mandatory 3-year, 10-year, or even permanent bar from being permitted to re-enter the United States under the Immigration and Nationality Act. Never signed anything at all, not in a hospital bed, not inside a detention facility, not in any government office, and not under any circumstances anywhere whatsoever, until you have personally spoken with a licensed and qualified immigration attorney who can fully explain every single word of every document to you. Now here is the legal shield we promised you. These are 4 specific legal protections that have not been rescinded and that actively protect every person inside a hospital right now in 2026. Shield 1 is the 4th Amendment of the United States Constitution. ICE agents are freely permitted to enter and move through the public areas of any hospital at any time. However, to enter any private or restricted area of the hospital, including patient rooms, examination rooms, and surgical areas, they are legally required to present either a valid judicial warrant that has been signed by a federal judge or obtain the explicit voluntary consent of a person who is legally authorized to grant that access on behalf of the hospital. An ICE administrative warrant alone is not legally sufficient for this purpose according to the ACLU and the National Immigration Law Center. This constitutional protection applies to every single person on United States soil. Shield 2 is the 5th Amendment of the United States Constitution. You possess the absolute and unconditional right to remain completely silent at all times. You are not legally required to answer any questions whatsoever about your immigration status, your legal name, your country of birth, how long you have been present in the United States, or anything else. This fundamental right applies to every single person physically present anywhere on United States soil regardless of their documentation status or immigration history. Shield 3 is HIPAA, the Health Insurance Portability and Accountability Act of 1996. This critical federal law actively and specifically protects your private medical information from unauthorized disclosure. Hospitals have no legal obligation to ask patients about their immigration status and no obligation to voluntarily report immigration status information to ICE or any other government enforcement agency. Your personal medical records and all health information you share with healthcare providers are federally protected under this law. Additionally, in the state of California, new state legislation signed into law in September 2025 adds significant additional protections that specifically restrict healthcare facilities from sharing patient information with immigration enforcement authorities. Shield 4 is EMTALA, the Emergency Medical Treatment and Labor Act, a federal law that has been protecting lives in this country since 1986. Under this law, if you arrive at any hospital emergency room experiencing a genuine medical emergency, that hospital is legally required to screen you and stabilize your medical condition before anything else. They cannot and may not legally ask you to produce immigration documentation before providing that emergency care. They cannot turn you away or deny treatment based on your immigration status. That federal law remains completely active and fully enforceable throughout 2026 and protects every single person who walks through an emergency room entrance in the United States. Here is your complete action plan. Write this down right now, take a screenshot, or save this video so you can refer back to it at any time. Step 1. Memorize this exact sentence and practice saying it clearly and calmly until it comes naturally and automatically. I am exercising my right to remain silent. I do not consent to a search. I want to speak to a lawyer. Then teach this exact sentence to every adult member of your household and make absolutely sure that everyone practices it regularly together. Step 2. Carry a printed Know Your Rights card with you at all times wherever you go. Both the ACLU and the Immigrant Legal Resource Center have printable versions of these cards available for completely free download online. The direct links will be posted in the description section below this video. If an IC agent approaches you at any time, hand that card to the agent silently and say absolutely nothing beyond the one sentence you have already memorized. Step 3. If you work at a hospital or any other healthcare facility, ensure that your team formally designates one specific authorized person to handle all direct interactions with immigration enforcement agents. Train every member of your staff to respond clearly and consistently by saying the following. I am not authorized to consent to your entry. Please present a valid judicial warrant that has been signed by a federal judge. Document every single interaction thoroughly, including the exact date, the exact time, the identities of the agents involved, and precisely what documents were presented during that interaction. Step 4. Create your emergency immigration legal plan today, right now, before you ever find yourself needing it. Have the direct contact information for a qualified immigration attorney saved and immediately accessible before any emergency situation arises. Have a clear and specific plan established for your children in the event that you are suddenly detained. Have power of attorney documents properly prepared and stored in a location that your family members can readily access at any time. This is not paranoia. This is responsible preparation for the reality of immigration enforcement in 2026. And let us say this final point with complete sincerity and genuine care for every person watching today. Please do not stop going to the hospital when you or your family members need medical care. EMTALA is active federal law, and your right to emergency medical treatment is fully protected under it. Children who need vaccines should receive them without delay. Pregnant women who need prenatal care and checkups must get them without hesitation. A survey conducted by Physicians for Human Rights found that 84% of healthcare workers surveyed across 30 states have personally observed a significant and alarming drop in patient visits since the immigration executive orders were formally signed. Children are arriving at emergency rooms completely alone because their parents are too frightened to accompany them through the hospital entrance. That fear is entirely understandable given the current climate. But deliberately avoiding necessary medical care can cost you your health, and it can cost your children their very lives. Go to the hospital when you need care. Know your rights inside and out, and exercise every single one of them with confidence. Everything shared in this video is fully accurate and verified as of March 2026. But this specific area of immigration law is changing with remarkable speed, sometimes shifting significantly from one week to the next as new court injunctions are issued, new state laws are enacted, and new ICE internal guidelines are released. What is legally accurate and in effect today could change meaningfully by next week. That is precisely why staying subscribed to U.S. visa and green card info is so critically important for protecting yourself and your family. When a rule changes, when a court issues a significant new decision, when a new state passes additional protective legislation, we bring you those updates immediately and directly. Subscribe right now and turn on your notification bell so you never miss a critical update that could directly impact your immigration case. Now please share this video today. Not for our channel numbers. Share it because right now someone in your family group chat still genuinely believes that hospitals are completely safe from immigration enforcement with no exceptions whatsoever. Someone in your community is actively avoiding the emergency room because of something frightening and inaccurate they encountered on social media. Someone you personally care about does not yet know the critical legal difference between a judicial warrant and an administrative warrant. This video has the real potential to protect them from making an irreversible mistake that permanently alters the course of their life. Hit the like button right now because it directly signals to YouTube to show this essential information to more people across the country who urgently need to see it. Subscribe to US Visa and Green Card Info if you have not already done so, and turn on the notification bell because our next video is coming very soon covering exactly what the latest ICE warrant developments mean specifically for your home and your family. You absolutely do not want to miss that one. Stay informed, stay fully prepared, and we will see you in the very next video.